So testing clerk microphone, which we probably won't use. So testing Justice 6, testing Justice 5, testing Justice 4, testing Justice 3, testing Justice 2, testing Justice 1. Testing podium.
Oh, all right. Yeah, you can kind of see over that.
The matter before the court this morning is Cumberland 26-288, Jane Gilbert et al. Versus the Secretary of State, et cetera. I see counsel are present. I'm assuming you're ready to proceed. Before we begin the argument, I would ask the counsel who are arguing, please identify yourselves by saying your names for the record. You?
Morning, Your Honor. Christopher Dodge for the Gilbert Cross Appellate.
Thank you. We are being streamed, as far as I know, on the web, both by audio and by video. And Attorney Woodcock, if you're ready to proceed, we'd be happy to hear your argument this morning.
May it please the court, Tim Woodcock here for the Protect Girls Sports in Maine Ballot Question Committee, appellant in this matter. What I'd like to begin by saying is what this appeal is about and what it is not about. What is at issue is an appeal arising out of a consent agreement in federal district court. The law at issue before the court is Maine law. And the controlling authority for this Maine law is the Pike Industries versus City of Westbrook case, Tennants Harbor versus the Department of Environmental Protection, as well as the West versus City or Town of Camden cases. What those cases stand for is that no Maine official, no Maine state agency can enter into a consent agreement that provides that official with powers that that official does not have, that has not been granted to that either by statute, lawfully, or under the Maine Constitution. I would add a corollary case that is, I think, illustrative here, is that of Avangrid versus Secretary of State. That case stands for the proposition that under the initiative amendments, the legislative power is limited. It's not without its ambit. And what that illustrates with the other cases is that this court has recognized absolute fidelity to the concept that when a state official acts, even when the people exercise their initiative power, they must stay within the confines of the Constitution. And what they cannot do is go to another court and get powers that the people have not given them. I would add also, in addition to that, what is at issue is the standards that this court has articulated over many years that govern the interpretation of the initiative amendments that are intended to give them life and to assure that the rights of the people, which they took unto themselves in 1909, in contradistinction to those of the elected legislature, are respected and facilitated and not impeded by actions of state officials. What is not at issue in this case is the inherent equitable or injunctive powers of a federal court. And what I'd like to do at this point is to address our principal argument, which deals with the out-of-state circulators. The out-of-state circulator issue arises out of federal litigation in We the People versus Bellows. And let me just give you a snapshot as to the end of that litigation. At the end of that litigation, the preliminary injunction was upheld by the First Circuit. It came back to the district court, and at that point, the parties had an
Counsel, I
opportunity.
see that the green light is on, and I'm going to ask a question where you are now. I mean, you started off your remarks by saying that Maine law controls, not the consent decree. There is a consent decree. There is a consent decree that was entered into by the parties that outlines what the Secretary of State can and cannot do with regard to out-of-state circulators. Agreed?
Yes, the consent agreement has those elements to it,
Okay.
yes.
What is the Secretary of State then supposed to do here, in your view, with that consent decree? Disobey it?
Well, that's an excellent question because,
Well, I appreciate that, but what is the answer?
well, first, I think there are two answers to it. One is, did the secretary under Maine law have the authority to enter into that consent agreement
But
at that
isn't,
point?
well, I'm going to stop you right there. There is a consent decree. Whether or not there was the authority to enter into it belongs in litigation in federal court. Right now, there is an order, period. And you can't collaterally attack that.
Well, let me respectfully disagree. I do believe that this court has jurisdiction to determine whether the Secretary of State had the authority to enter into that consent agreement. I think that is a matter of state law, and I think that is determined by Pike Industries and the other cases that I related earlier.
But we don't have the power to vacate that injunction, do we?
No, but let's look at the elements of that consent order. So the first paragraph in that,
Well, actually, putting aside, ignoring the consent order, what do you think the Secretary of State is supposed to do, putting aside our power?
I think the Secretary of State has entered into an agreement that she did not have the authority to enter into. But let me break down the consent order because I think that's really where the interesting questions lie. The first paragraph of the consent order.
I understand you want to do that, and I'm going to let you do that in a minute, but I guess I still want an answer to my question. I mean, do you agree that in this case, what the Secretary of State did is in line with the consent decree?
No, I do not.
Okay, well, there.
No, I do not. No. But, Your Honor, you have to give me an opportunity to break down the consent order.
Go ahead.
Now, so let me do that. So the first part of the consent order is judgment entered against the residents and, or for the plaintiffs who were challenging the constitutionality of the residents and registration requirements. Judgment was entered for them. So they are unconstitutional as violative of the First Amendment. That's the first part of this consent order. The second part of the consent order, it has two elements to it, two broad elements. There is an injunction imposed against the residence provision, and then in paragraph 3, there's an injunction against the registration, a straight injunction, not diluted by anything. Then you look at paragraphs 2A through C and in the consent order, and what are they? From an injunctive perspective, are they prohibitory? They do not appear to be prohibitory. Are they mandatory? Not in the sense of an ordinary injunction because they lack specificity. So the question then becomes, well, what are they? Now, the Superior Court reached the conclusion that they were mandatory, that essentially what the District Court had done was issue a mandate to the Secretary that the Secretary was absolutely obligated to observe. The petitioners have argued that if the Secretary didn't comply with that, the Secretary could be held in contempt. But what exactly did the consent order advise the Secretary? Well, it created, as the petitioners and the Secretary would have it, a carve-out of the Maine Constitution. That is
And
not.
your position is that there is no carve-out, that that the Maine Constitution is just unconstitutional and you can allow out-of-state circulators to do whatever?
There is, no, the Maine Constitution's residence and registration provisions are absolute provisions. They have no qualifications to them. They have been found to be unconstitutional. They have been adjudicated unconstitutional. They are unenforceable. But at that point where the court made that decision, the ball should have shifted to the people of Maine. The people of Maine should have had the opportunity.
Could the legislature enact a statute consistent with the consent decree and what the Secretary of State did in this case,
No.
requiring out-of-state circulators to execute jurisdictional affidavits?
Cannot, because the Maine Constitution has an absolute prohibition on out-of-state circulators. And the authority that the legislature obtains to legislate with the initiative amendments comes solely from Article 4, Part 3, Section 22, and that says the legislation cannot be inconsistent with the Constitution. Well, the Constitution has an absolute bar, and if the absolute bar is no out-of-state circulators. And for that reason, and we'll get to the end of these arguments at some point, that is why the state can't come over and graft onto the consent agreement statutory authority like the circulator's oath provisions, because the authority for those can only come from Article 4, Part 3, Section 22, and we still have the flat prohibition on out-of-state or against out-of-state circulators in the Constitution, which the people of Maine have gone out and recently reaffirmed. That is their wish, that's their choice. None of the statutory provisions on which the Secretary is relying can apply because they derive their authority solely from the initiative amendments, no other place. And nothing in a court order can, in a federal court order, can change that. But let me go back to the
So your tipping point is that there's the injunction out there, but that we are not bound by it, or we should overrule it or modify it?
I'm not asking you to modify it. I'm asking you to determine what the Secretary's authorities are under the Maine Constitution. And the Secretary's authority under the Maine Constitution is to abide by the, not to create situations in which he is facilitating out-of-state circulators. The out-of-state circulators should be able to come into Maine on the same plane as everybody else. What the Secretary cannot do, and I think to the Chief Justice's question, could the Maine legislature enact legislation that essentially paralleled what's in the consent order? No, because the Maine Constitution bars out-of-state circulators, and it will continue to bar out-of-state circulators until such time as the people of Maine change the Constitution and come up with provisions. The people of Maine, if they wished, should have had the opportunity to adopt or not the provisions in the consent order.
Counsel, are you saying that the federal court held that, the First Circuit held that the Maine constitutional provision regarding out-of-state circulators violates the First Amendment across the board? Is that your position?
It violates the out-of-state, or the prohibition on out-of-state circulators violates the First Amendment.
Across the board, no exceptions?
No exceptions. There are no exceptions to that. And these provisions that came into the consent order, and I do think they need to be examined. A couple of things to...
I'm a little confused. Why do you say that there's no exceptions when the First Circuit said available here was requiring out-of-state circulators to provide up-to-date contact information and to submit to legal process in state?
Because, if I may, Your Honor, that was a court going through an exercise of examining whether the provisions were narrowly tailored. They weren't blessing those provisions, they were simply examining them to say,
well, let's back up. The Secretary of State has a duty to obey the Maine Constitution.
yes,
The only exception is she can't do it to the extent that federal law overrides that, correct?
that is true.
So the federal court said it's unconstitutional under the First Amendment to have a flat ban, but you can have a consent to jurisdiction. And now I want to understand why then it isn't her duty to enforce what's left of the state constitutional provision under her oath.
Because the federal court did not say that. The federal court was going through a strict
But she
scrutiny.
has that duty independently to enforce what's remaining of the state constitution, regardless whether the
But then
federal
nothing
court
remains.
told her to or not.
Nothing remains. These are absolute prohibitions.
And when you say the federal court didn't say that, I suppose we could read the First Circuit's analysis in the way you'd like us to, but the consent judgment itself says, you know, it's not, you can, just can't enforce it so long as you have these exceptions. So putting aside what the First Circuit might have said was or was not constitutional, we have a consent judgment that she's bound by. Isn't that correct?
Then let's look at the consent agreement. The consent agreement says nothing in it about when an out-of-state circulator must consent to jurisdiction. It does not say how the out-of-state circulator consents to jurisdiction. It does not say what event triggers an out-of-state circulator's consent to jurisdiction. The sole source that the Secretary is relying on for that is Maine statutory law, and it can't come from that source. Reading the consent order fairly, and I would say in the context of the imperatives that are supposed to be applied by the Secretary to preserve the right of the initiative, that consent order could be read that one complies with it if one is asked to respond to a request. So, for example, in this case, nobody did ask any of these out-of-state circulators to consent, and therefore they would not have been in violation. You look at of the consent order, because the consent order has no specific provision as to when they must consent or under what circumstances. When the circulator Cairo consented, she came forward of her own volition. And I do think it's, I think the court,
Consented way after the fact.
well, was it, no, I don't agree, Your Honor. Not in terms of the consent agreement.
Thank you. Are there additional questions from the bench?
Well, you've lost me. There were the Constitution provides for the legislature to come in and to help implement the initiative amendment. So why can't the Secretary of State rely upon statutes that were passed in order to help effectuate the initiative?
Because the authority for the statutes comes from Article 4, Part 3, Section 22, which says you cannot pass statutes inconsistent with the Constitution. And the Constitution says, still has, and the people have recently confirmed, the bar against out-of-state circulators. So you cannot derive legislative authority from the main Constitution for that. And there's nothing in the consent agreement that suggests, I mean, the Secretary of State helped to draft this consent agreement. And if the Secretary wanted those kinds of specific provisions, then they could have. And I would say to this court, I think it's very important here. We are talking about the invalidation of otherwise valid elector signatures who have the right to petition the government and the actual
I understand,
removal of
counsel. Your time is actually up, but if there are, that's now, I think, not responsive specifically to Justice Lawrence's question. Are there additional questions from the bench?
I do have a question just about that last point. Are you making a separate argument about the remedy? Suppose we reject your argument about the circulators. Are you making a separate argument that even if the circulators were not valid, we shouldn't invalidate the signatures or not? I was a little unclear from your
No, I
briefs.
appreciate that. What I did say in my brief, and I think it's important for the court to focus on this in terms of the context of the consent agreement. The Secretary made representations both to the District Court and the First Circuit that the remedy for this jurisdiction would be subpoena power over the circulators. Nothing in the consent agreement suggests that the federal court empowered the Secretary to invalidate signatures that are otherwise valid and to take an initiative off the ballot on the strength of a consent order from the federal court. There's nothing in the consent order that says that. And in the opinions, both opinions, the First and Circuit and District Court opinions, the reference to the subpoena power, which the state said was in effect, which has turned out not to be in effect, suggests that the federal court would have assumed that the remedy would have been to hold the subpoenaed circulator in contempt. That would have been the remedy, not interfering with the initiative process and taking an initiative off the ballot.
Additional questions from the bench?
Do you agree that under the First Amendment, it is just the First Amendment, it's constitutional to impose a consent to jurisdiction requirement?
I'm not following the question, Your Honor.
That there's nothing in the First Amendment that would preclude requiring that circulators consent to state jurisdiction?
I think that is a question of state and federal power. And I think when it comes to state and federal power, if the federal court is trying to infuse a state official with authority that state official does not have, then that's
No, that's not my question. Under the First Amendment, can a state impose a consent to jurisdiction requirement? Just the First Amendment.
Well, no, but the provisions in the consent order have never been adjudicated as
I'm not talking about the consent order. I'm talking about the First Amendment.
Yeah.
Does it preclude a state from imposing a consent to jurisdiction order? There are 4 courts of appeal that say it doesn't.
I would say it would depend on what the provisions would be and if they have been adjudicated as consistent with the First Amendment, which is not true, by the way, of all the provisions in Section 2A through C. Every one of those provisions is in there because it was an example of more narrow tailoring. Courts don't do the tailoring. It's the legislative authority that does the tailoring. These are just examples of less restrictive, less burdensome impositions.
Are there additional questions from the bench?
Yes, I have a question. It may actually be a couple of questions. You're focusing on the timing of the consent. The secretary here found, as a matter of fact, that Cairo consciously declined to consent. How many times do people get to change their mind? I mean, if that's a finding, and we have to defer to the secretary's finding, doesn't the record establish that she declined? Understand that she came back later and changed her mind.
But the timing that the court is relying on is not coming from the consent agreement. It's coming from the circulator statute. And the circulator statute can impose that timing limitation on the consent agreement. The consent agreement has no timing element in it. It has no description of when one must comply or how one must comply.
Accepting that, if someone says, no, I'm not going to consent, but then 2 months later says, you know what, okay, I will consent.
But, Your Honor, the occasion for her doing that is arising from state law. It's coming from the circulator form, which the Secretary says is coming from Section 21. The authority comes from Section 20 of Title 21A. Section 21 of Title 21A cannot be authority for creating special conditions for out-of-state circulators because they are simply barred. The only source for the Secretary's power is the consent agreement, to the extent it has, and it doesn't resemble, your ordinary injunction, but the only authority is coming from the consent agreement, and the consent agreement has no timing element in it. And it really reads as though if you seek the cooperation of a circulator at some point, an out-of-state circulator, and they don't respond, then they don't come within the protection. But Cairo came forward, and she did participate, even though nobody wanted her to, at least on the Secretary or the petitioner side, because all of her petitions were valid. And the consequence is, as you look at that consent agreement, and I would ask you all to look at it very closely, there is no timing element in it. There's no description of how you consent, when you consent, what event causes you to consent. So you cannot find on the strength of the consent agreement that she failed to comply. You have to incorporate the statute, which the Secretary is importing, but you can't do that because it comes under the authority of the initiative amendments. They don't allow out-of-state circulators.
So even though someone initially says, I will not consent, they can change their mind?
Well, I mean, the only reason she was asked whether I would consent or not, and she simply deferred the matter was her testimony, but the only reason she was asked because the Secretary was relying on the authority of Section 21A to amend the circulator's affidavit, and that's where that timing provision came from. If we really are confined to the consent agreement, and I think we are, then there would have been no occasion to ask her that. It would have been triggered when she was asked to comply, and she did comply, even though neither the petitioners nor the Secretary asked her to do so.
Can I just follow up on that? You say the only source of the Secretary's authority is the four corners of the consent agreement. Do you agree that the Secretary has an independent, freestanding prerogative and obligation to ensure the appropriateness and the sanctity of the process we're talking about here, the people's referendum?
Well, it comes from the Secretary's constitutional authority. But I will also say in that regard, Your Honor, and the district court made this very clear, there are some guarantees built into our initiative process. One is all the signatures have to be those of Maine electors. So that's the district court saying. And ultimately, it's the people of Maine who decide for or not against whatever the proposed initiative is. Those are also guarantors. The overarching obligation of the Secretary, which she has never mentioned in her briefs, are the imperatives that this court has repeatedly articulated about making sure that we respect the sovereign authority of the people and we do what we can, as the opinion of the justices said in 1971, to effectuate the exercise of the initiative power.
Can the consent agreement dial back the Secretary's authority or prerogative or duty?
Well,
otherwise freestanding and existing?
I don't think the consent order did that. It seems to me what the consent order, with the secretary coming in, and it appears to have been a non-adversarial setting, was to give the secretary a workaround for the Maine Constitution. That's what it appears to have done. And I would say in the process, it's enervated the political process here, because what should have happened is the people of Maine should have reconsidered the absolute exclusion coming from the out-of-state circulator ban and come up with whatever conditions they wished to allow them in, which might have been the very same as we already have. Maybe no change at all. Maybe they would have rejected those provisions that are in the consent agreement. We don't know because they haven't been given that opportunity.
Additional questions from the bench?
And I know you disagree as to whether or not there was a failure to comply, at least talking about the one collector. But to the extent that there was a violation, arguably, by her not consenting to jurisdiction of the state of Maine, do you agree that our case law suggests, I'm thinking of Reed versus Secretary of State, that the consequence of failing to comply may be, in fact, that a petition and the signatures on that petition are now excluded?
I think, Your Honor, it depends on the circumstances, because as I read the constitutional directives coming out of this court with the need to protect the people's exercise of this, it would have to be a significant violation to warrant the invalidation of a signature or a whole petition. It would not be something done casually. And I would say, in the Secretary's perspective, in the Secretary invalidating a whole petition, she should both be citing those constitutional imperatives to preserve the right of the people to exercise this right, and showing demonstrably how she has done so, and she has not done so. So I think part of what's missing here is we have not seen the Secretary go through what I think is a constitutionally directive requirement to apply those standards to the invalidation of petitions. This is quite dramatic. I mean, and we should be under no mistake about this. If this is upheld, it's essentially an initiative has been pulled off the ballot with 1,520 otherwise valid signatures on the strength of a federal court order. That would be a remarkable result under these circumstances.
Additional questions from the bench? Okay, thank you.
Thank you.
Attorney Dodge, we're happy to hear your arguments.
Good morning, Your Honors, and may it please the Court. Christopher Dodge on behalf of the Gilbert petitioners. The Secretary's revised determination rightly concludes that PGS failed to submit enough valid signatures, and this Court should affirm the Superior Court's decision upholding that well-supported finding. This litigation began when petitioners came forth with irrefutable evidence of wrongdoing by numerous circulators, out-of-state circulators, paid by PGS. And it bears emphasis that virtually none of those allegations remain in dispute at this stage of the litigation. The Secretary conducted a hearing on remand at which evidence showed that PGS circulators abandoned petition sheets, swore false oaths, and submitted false signatures. And tellingly, PGS does not challenge any of that on appeal or suggest that the Secretary clearly erred with respect to any of her factual determinations. So we are here today because PGS has essentially reached to the bottom of the barrel for its last few arguments to try and dislodge the Secretary's well-reasoned and well-supported finding. And each of those arguments basically concedes that the initiative violated the letter of Maine law, but it asks for a get-out-of-jail-free card that the Superior Court rightly denied it. I intend to focus primarily on the non-resident circulator issue. PGS's brief raises a lot of sound and fury on this issue, but I think distilled to its essence, its argument boils down to three primary tentpole propositions, many of which have already been discussed, and all of which are easily dispatched. The first and the biggest is PGS claims that the Secretary cannot enforce any restrictions on non-resident circulators because those restrictions are not set forth in the Maine Constitution. That claim starts from a fundamentally confused and false premise. The Constitution does grant the Secretary regulatory authority over non-resident circulators, and it does so by giving her the authority to ban them entirely and to invalidate their petition sheets.
I want to make sure I understand the argument you're making because of some remarks you made in your brief. The consent order doesn't empower the Secretary to do anything, does it?
I strongly agree, and any language to that effect, I think, perhaps slightly confuses where her authority originally derives from. It originally derives from the Maine Constitution. I agree, it derives from Section 20.
So when you say things like the secretary's duty to act arises from the consent order, it arises from the Maine Constitution, correct?
In the first instance, yes, it arises from Section 20, which imposes upon her a mandatory duty to prohibit non-resident circulators. Now, of course, and that, to be clear, is the power she exercised in the first instance here. Now, to be clear, because the secretary has dual obligations under state and federal law, she has to balance both of those obligations, and therefore her duty to enforce Section 20 runs up to the greatest extent permissible under federal law.
So she has to comply with the Maine Constitution to the extent she can, so everything that is not precluded by the injunction and the order, correct?
Yeah, Justice Connors, I'm willing to adopt your formulation in the question you put to Mr. Woodcock, which I think is exactly right. The Secretary has a residual mandatory duty to enforce Section 20 to the greatest extent permissible under federal law. And here we have federal court orders that delineate, the specific carve-out that she's not allowed to enforce. And that's what happened here. There were 116 non-resident circulators who we never challenged because they brought themselves within the safe harbor of the federal court order. There are 4 who did not, and they are subject to the still vital Section 20 resident, ban on non-resident circulators, which remains operative. Nothing in the federal court litigation invalidated Section 20 in full. And that's another sort of core assumption of PGS's argument, which is that the federal court had a very limited menu of invalidating Section 20 entirely or leaving it fully intact. That's not how federal equity practice works.
So there's no statute that it exists now that specifically provides that the secretary can impose the consent to jurisdiction requirement, correct?
I think if I'm in the secretary's shoes, I start first with my obligation to enforce Section 20. I then have to make sure I'm doing it in a way that is not violative of federal law.
Well, her question is, there's no statute that delineates what she should do.
Well, I think there's a statutory overlay. I agree it's not expressly spelled out jot by jot in statute, but statute does, for example, create the circulator affidavit.
So her authority comes from the duty as a constitutional officer to enforce the Maine Constitution to the extent that she is able to do so without running afoul of the Supremacy Clause.
I think that's right, and I think that comes both from her obligations in the initiative amendments and also her obligations under Section 905 that require her to determine the validity of the petition in a specified review window.
So what is the standard of review that we use to determine whether the consent to jurisdiction requirement is within her power to enforce the Constitution, Maine Constitution, as much as she can?
I think this gets to your earlier question of whether or not it violates the First Amendment in the first instance to impose a jurisdictional requirement on non-resident circulators. And the uniform answer of a half dozen federal appellate courts is no, it does not violate the First Amendment. And I think it's important to actually look at the burden here that is imposed on the non-resident circulators. 116 non-resident circulators whose conduct would have been unlawful 5 years ago had no issue checking this very clearly labeled box that is bolded, underlined, you must check one. In fact, Cairo, the only non-resident circulator who testified, acknowledged she saw the box, but she didn't want to check it. The burden on if you're conducting a First Amendment analysis in the first instance, you look to the burden on the protected conduct. The burden here is they have to complete the circulator affidavit, which is a longstanding aspect of Maine law, and they have to check a box. That's it. It is the most de minimis burden possible. And most of the non-resident circulators had absolutely no problem complying with it.
So when we're determining whether it was reasonable or whatever the standard is for the secretary to impose this as a mechanism to continue to enforce the Maine Constitution, the fact that the First Circuit indicated that it's okay to impose this requirement is something that is relevant to that analysis?
Well, I think it's relevant because another state law duty the secretary has is to promulgate all election forms. That's Section 21 of Title 21A. That obviously includes the circulator affidavit. This court's precedents make clear that the circulator affidavit is the mechanism by which the secretary ascertains the qualifications of the circulator. And that's an indispensable constitutional requirement, discerning the qualifications of the circulator. So the secretary has a duty to issue this circulator affidavit, the indispensable form for determining circulator qualification. And I think it's well within her discretion as the executive officer with plenary authority over this process to update that form that the legislature has tasked her with designing and promulgating to be compliant with all the relevant laws here to reflect basically to the letter a binding federal consent order.
Counsel, would you agree that the consent order itself says nothing about timing?
I don't know that I agree with that, Your Honor.
Well,
And I
show me
think
where it does.
Well, Your Honor, I think consent orders, just like any court ruling or any statute, have to be read with some measure of common sense, and that consent order is issued against a statutory backdrop that exists here in Maine that sets, one, a constitutional deadline for submitting the petition, and you can't submit any other material after that constitutional deadline. You can't come back and fix a signature, fix a notarization. It is against the statutory backdrop in 903A that all circulators have to submit their forms by the time the petition is filed, which is not a deadline drawn from thin air. It ensures that the secretary has those materials for her brief 30-day window of review.
But the other provisions, B and C, 2B and C in the consent order, seem to contemplate sort of post-election activities. You know, this is all designed, is it not, to make sure that the secretary can investigate and determine whether there's been the petitions are valid and the signatures are valid. Two of the three pertain to post-election activities. Why is it unreasonable to read 2A in the same light? In other words, the secretary has the address, knows how to contact the circulator, calls up and says, you need to come in.
I think there's two aspects of that question. One is how to read the consent order, and the second is why to read it a certain way. As to the first question, I think it would be rather remarkable to read a federal consent order to sub silentio basically say, we're going to set aside all the state law deadlines. We're going to set aside the constitutional deadline that creates a hard end date for when all the initiative materials have to be submitted. We're going to set aside the statutory deadline for when the affidavits have to be submitted. We're going to ignore that the secretary has a discrete 30-day window to review tens of thousands of signatures and just silently suggest, yeah, you can submit it whenever you feel like it. And rather than submitting it ex ante so that the secretary has all the information at her fingertips, we're going to basically require that every single initiative result in litigation, because the finality that is supposed to come from the determination of validity, well, none of it's actually final. And they have to put an asterisk next to every signature they invalidate due to an unqualified circulator so that the various parties can file lawsuits and have dozens of interviews with out-of-state circulators where they can come up and say, well, actually, I did intend to submit, I forgot, or I was confused. I mean, that's just a completely unworkable system for the secretary.
May I?
Go ahead.
Why is it unworkable? Secretary calls the circulator on day 15. We're looking through all of these materials. Secretary says, will you consent to jurisdiction? Circulator says no. Okay, they're out.
Well, consider the fact that there were 120 non-resident circulators here. If the obligation to check the box and to complete a full and sufficient circulator affidavit is actually, you sort of get a mulligan on it. If I'm a non-resident circulator and I know there's criminal liability under Maine law, and there's some funny business in this initiative, certainly, and I know there could be some trouble for me, why on earth would I check the box? I would make them call me. Maybe they won't notice and it won't be an issue. And if a lot of them don't check the box, you're having a very short-staffed secretary's office during this narrow 30-day window calling dozens of circulators in Arizona, California, Georgia, Florida. That's not an administrable system. And it's why the First Circuit, in drawing the line that it did, realized that there is a really valid state interest here. I mean, one thing my friend Mr. Woodcock says is, well, non-resident circulators should be on the same plane as Maine residents. That's what the consent order accomplishes. It attempts to put them on the same plane as Maine residents, where the secretary has subpoena power over them, typically has a voter registration file, so it knows where the person lives and how to contact them. The entire point of this is to say, yeah, we recognize non-resident circulators have some First Amendment skin in the game, but they can't just come in willy-nilly without restriction. They have to be functionally put on a similar playing field to Maine residents as far as their obligations to the secretary. I'm not sure where I am with my time.
You're out of time, but if there are additional questions from the bench before we hear from the secretary.
I'd just like to ask, there is some jurisprudence going back in time where the justices of the court back then were sort of inclined to say, well, if there's some irregularity taking place in the petitioning process, the voters, we don't want to disenfranchise the voters of the signatories, so we'll just kind of go ahead with that. And that, as the parting shot, the committee said basically that an enormous number of signatories were wiped out off the picture here, and that is a travesty of justice because their voices weren't heard. I'm just interested in your response.
I appreciate that question, and I know it was asked earlier. It gets to sort of the remedial question here. And I guess I have a few answers. As far as sort of like where the justices previously have suggested, oh, you can sort of get a mulligan on this one and not the others, Reed said this very plainly. A qualified circulator is a constitutional requirement for a valid petition. And then MTAN goes further and says, our precedent is uniform on this question, that a resident who does not comply with constitutional and statutory requirements is invalid. And on this remedial question, there is an unbroken chain of precedent from this court going back 100 years that says that the presumed remedy for circulator irregularity, error, misconduct is invalidation of their petition sheets. And I don't think that's an arbitrary choice. It stems from the initiative amendments themselves. When that power was granted to the people, it came simultaneously with a fairly substantial host of regulations, obligations in order to place a valid initiative. And all of those basically have to do with the issues here today: improper notarization, improper circulator conduct, non-resident circulators. That grant of authority to the voters came with responsibilities to initiative sponsors to ensure that their circulators abide by the letter of the law, and here they did not. So, you know, my friend, Mr. Woodcock, suggests it's problematic, this remedy. It's actually, as far as I can tell, the only remedy this court has addressed. No federal court has called it into question. The District of Maine, the federal district court in Hoffman, endorsed it. The We the People decision didn't call it into question and basically said Section 20 remains in effect, and under Hart, invalidation is the remedy for Section 20.
Thank you. I think I got it. Thank you.
Justice Lopez, did you have a question?
I did have a question. I understand you're characterizing sort of the interplay between the state constitution and the federal consent order as leaving the secretary in a position where she can enforce the constitutional provision to the fullest extent allowed under federal law. I think the response from PGS might be that's not really what's happened. What's happened is the secretary is relying on this federal consent order to really rewrite the state constitutional provision. Can you point to another case where a federal consent order or judgment has been used to narrow a state constitutional provision in this respect, as opposed to just saying, you know, it's unconstitutional under the First Amendment or whatever provision, so you can't enforce it?
I don't know that I have a case involving a consent order immediately at hand, although frankly, I'm quite sure that they are readily found in the federal reporters. But what I would say is a consent order isn't as special as it seems to be made out to be here.
And I'm not saying just a consent order, any
Sure.
federal judgment that says you can enforce the state constitutional provision, but only in this respect. Can you point us to some of those cases?
I mean, I think I initially had a dozen in my brief before I had to cut them. I mean, AOD is sort of the easy one because it's a very clean articulation of that exact principle from the Supreme Court. I don't think it involved a consent order, but it stands for the proposition.
That didn't involve a state statute?
It did. It involved a New Hampshire state statute.
I'm asking about the constitutional provision.
I don't think for purposes of the supremacy clause it matters. I mean, Reynolds v. Sims in the election law context is a canonical one where various state constitutions on reapportionment were, I don't know if they were fully invalidated or partially, but certainly for purposes of the supremacy clause, you know, state constitutions are due all appropriate respect. But at the end of the day, federal preemption applies just as evenly to a state constitution as a state statute. And for purposes of, you know, federal equity practice, I don't know why a federal court saying, I want to leave this in place to the greatest extent possible, so I'm going to adjoin its applications in specific ways. I think that rule, again, well articulated in AOT and many of the cases cited therein, I think it's the same principle and logic.
Whether it's a statute or
I think so.
Constitution provision. All right, thank you.
A little off topic. Did you cut those cases because your brief was over your word count?
I don't think it was over the word count.
Okay.
But it was close, and so some of those briefs, you know, some of those things had to fall by the wayside.
Okay, thank you.
One further question. I just want to check on something you said, that the effort to have collectors to sign off on their to the jurisdiction of the state of Maine, put them on the same level as individuals in the state of Maine going around and collecting. But that's not actually accurate, though. To the extent that you're talking about collectors, they bop all around the country for purposes of engaging in that activity. And if they fail to check the box, following up with them is, as a practical matter, could be extremely difficult. And especially when you've got a 30-day deadline for the Secretary of State in order to effectuate dealing with any challenges that are put forth.
I mean, I couldn't agree more strongly. And I think if you look at the facts of this case, to the extent the intervener is understood to be raising some sort of as-applied challenge, we identified 4 non-resident circulators. The other 116, you know, they played by the rules. The 4 at issue, 3 of them have never gotten in touch with the secretary. They blew town. The 4th acknowledged that she saw the box and chose not to check it. So where's the burden on their First Amendment circulatory conduct? It's a very reasonable request because, again, the box is not just the consent to jurisdiction. It's also agreeing to keep updated contact information, which is very important. I mean, incidentally, Cairo changed her primary address in her second circulator affidavit, which is well within her rights, but I think it speaks to your point that a lot of these professional circulators move about the country. They're very hard to track down, especially in a 30-day window with narrow staff. So I think, you know, requiring ex ante a hard rule that, yeah, you got to do it before you submit the petition, before the secretary rolls up her sleeves and looks at all this, is very reasonable and certainly kosher under the First Amendment.
Additional questions from the bench? Thank you, counsel. Attorney Bolton.
Madam Chief Justice, and may it please the court, Jonathan Bolton, Assistant Attorney General for the Secretary of State. Before I start my argument, I just want to mention something, a more practical point, given that there's been, by Gilbert, a request for a remand in this case, which is that the Secretary's deadline to finalize the ballot for this November is August 25th. So
Our statutory obligation is to issue a decision well in advance.
I understand, Your Honor, but my client asked me to put it on the record, so I'm doing that. So I want to talk a little bit about the We the People injunction to start, and I want to address head on this idea that this was some sort of collusive agreement between the Secretary of State and a set of plaintiffs. To be clear, this was an adversary proceeding. We didn't agree that Section 20 should have been enjoined at all, and the first time that this consent to jurisdiction part of the injunction was implemented was by the district court in an adversary proceeding and a preliminary injunction proceeding. So we didn't write that. That was imposed upon us by the district court. We later, once the writing was put on the wall by the First Circuit, that this provision was not going to be able to survive in its full form.
So are you saying that
Now she is.
that the injunction is not part of the law of the land, that it's narrowly focused on this case? I'm just wondering why you're leading off with that, the fact that you don't agree to the underlying principles.
I think there is a suggestion that the Secretary of State somehow sort of manufactured this consent order in order to expand her power, but this was something that was imposed on us. We wanted to be able to enforce all of Section 20. The district court said, and the First Circuit said, we were not going to be able to do that. So the consent order was basically a way for us to salvage some aspect of Section 20 that we could continue to enforce rather than being completely unable to regulate
circulators. You didn't salvage, is that the done deal? Is that the law of the land going forward?
Well, the Secretary of State is permanently enjoined from enforcing Section 20. So from our perspective, it is the law of the land.
Okay, so the fact that you don't agree with it is neither here nor there at this point.
It is neither here. I agree.
Okay.
It's neither here nor there. My only point is that this was not something that the Secretary thought up on her own.
So let's focus on the Secretary's authority to require the consent to jurisdiction. It's pretty clear that the people of Maine would like no non-resident circulators, correct?
Agreed.
So is it your understanding that under the Maine Constitution, the Secretary has the duty to enforce that to the extent she is not precluded by the permanent injunction and consent order?
Absolutely. I completely agree with that. I think she's sworn oath to uphold the Constitution. The federal court has now specified the applications in which the Constitution may still be enforced. and she absolutely has not just the power, but the obligation to enforce Section 20 to the greatest extent she can.
Okay, so I want to then focus on this timing requirement.
Yes.
Is there anything in the injunction or the consent order that precludes the timing that the secretary follows? That says she can't impose the requirement at the time, the affidavit must be submitted at the time the signatures are submitted?
No, absolutely not, Your Honor. There's nothing.
Okay, so is that particular requirement, the timing requirement that the secretary has imposed, that's not governed by strict scrutiny, is it? Because it's not, that thing is not imposing a severe burden within the meaning of Meyer v. Grant or Buckley. So we would just look to see whether it's reasonable?
Absolutely. The timing, a deadline placed at the end of the circulation process does not impose a severe burden on circulators. I mean, I think arguably, you could make them do it before they start circulating. That's not the way our statutory framework works.
So I think the courts say that if it's not strict scrutiny with election laws, then you look at a less exacting or a balancing test. They have different ways of describing it. However it's described, how does this timing meet that test?
Well, Your Honor, I think we have, the state has a compelling interest in being able to investigate circulators during the 30-day period after the petitions are submitted. So that's the compelling interest that the state has.
There are about 70,000 signatures that needed to be.
I think it might have been closer to 80, Your Honor, the high 70,000s, I think.
So she had 30 days to
30
go
business days.
through 80,000 signatures.
Correct. It is, I can tell the court, it places an extreme burden on Secretary of Staff to go through this process and to look at all
So
the
how does
signatures.
this timing assist her in that task?
Well, because to the extent issues come up about circulators, her only opportunity without having to go through judicial review and have a remand, as was what happened in this case, would be to try to do some sort of investigation in that period. I'm not disputing it. It's very difficult with the staff burdens that are placed on the Secretary of State, but that's the opportunity to do it in order to reach a determination, as she's required to do under the statute, as to whether
So she can look
whether
at
this
these
petition is valid.
particular pages and she could say, oh, they didn't sign the affidavit, good. I don't have to look at those signatures.
I don't think that that's the approach that would be taken in terms of good. They wouldn't say good, but I think the
Well, it facilitates her ability to count.
I think what should have happened, it did not happen in this case, but what should have happened in this case is that someone should have caught that there were those 4 circulators that did not consent to jurisdiction, and those signatures should have been set aside. That's
And
correct.
in this case, as it happened, the petitions were really filed essentially at the 11th hour. So there
They
really
were filed-
was no opportunity to cure.
That's correct, Aaron. They were filed on the deadline, and we've argued that the correct deadline is the statutory deadline in 903C, which is where the legislature addressed residency requirements. So it's where it housed the Section 20 requirements in the statutes. But I would also submit that if the court has any concerns about that statutory deadline, clearly the constitutional deadline applies. I mean, you've said, at least the justices, in an opinion of the justices, said as far back as 1915, that after the constitutional deadline passes, you can't go back and fix things, you're done once the Constitution deadline has passed.
The consent to jurisdiction component of the federal court order is one of 3 conditions.
Yes.
So you may not know the answer to this question, and maybe a little extra record, but suppose someone does check the consent, the circulator does check it, the secretary has a suspicion, questions some of the signatures, attempts to contact the circulator, is unable to do so, even though they've consented. What happens then?
I think if it turns out that the reason why they can't get into touch with the circulator is because, say, they haven't updated their contact information as they're required to, I think the signatures would be properly invalidated at that point, because they'd be in violation of the affidavit that they agreed to. Yeah.
So when we're exploring that the secretary's decision to impose the consent to jurisdiction was within her authority, Do we defer because she's the administrating to the election laws to her determination? What kind of standard do we use in determining whether this was a reasonable exercise of her constitutional power?
I think it depends probably on the mode of analysis that you're using, Your Honor. I mean, if you're just considering flatly, is it unconstitutional? Does it, which I think is Mr. Woodcock's argument, does it literally violate the terms of Section 20 for her to require consent to jurisdiction? That would be a de novo question. I also would submit it's a very easy question that it clearly does not violate Section 20. But then if you're looking, I think, more at, is the Secretary exercising the discretion that she's given under these various election laws, including the discretion to determine the validity of a petition under Section 905? I believe that's largely an abuse of discretion standard, Your Honor. I think I've covered most of what I wanted to say, Your Honor, but I just want to make this other point about the constitutional deadline, which is that, and I think Mr. Dodge made this point, he stole my thunder a little bit, but I want to just point out that if there really were no deadline, there would be a huge problem with administering this statute and in this rule, one of which is that judicial review would, instead of becoming error correction by the Secretary of State, it would actually become an opportunity for the petitioners to fix problems with their petitions. And so we would have, instead of looking at did the Secretary make a mistake, which is supposed to be the point of Rule 80C review, we'd be looking at, well, let's give them an opportunity on remand to fix things that they got wrong the first time around. I think that's extremely problematic, and I think it would lead to a lot of gamesmanship. I mean, especially if you imagine a situation of a circulator who knows maybe that they did something wrong and is very concerned about that, then I think we're going to have a hard time ever getting them to consent to the jurisdiction once they find out that their signatures aren't needed to get over the constitutional threshold. And I'd point out here too that it's not just the Secretary's review of validity is extremely important, but there's also a criminal overlay to all of this as well. And so a failure to consent to, again, once they've gamed it out and they know their signatures aren't going to matter, there's going to be a strong incentive not to consent because they're not going to want to subject themselves to potential criminal prosecution if any misconduct comes to light.
Thank you. Additional questions? Yes.
What's your response to Attorney Woodcock's answer or reply to my question as to whether or not it's appropriate to rely upon the statutes that were effectuated to, in fact, implement the initiative amendment, to the extent that you would look to a statute per se to find out what the deadline is for filing? And he suggested that that was all invalidated by the injunction.
No, I think it's absolutely appropriate. I mean, the statutory, the Constitution in Section 22 provides the legislature with authority to provide the statutory overlay. This court has said, it will look at the statutory overlay when it's determining whether petitions are valid. It looks at the statutory overlay as well as the constitutional provisions, and I think that's also what gives the Secretary some measure of her. I think she has constitutional authority as well, but the statutes also empower the Secretary to conduct her review and to apply these different rubrics. So I think absolutely the statutes are authorized by the Constitution and they are extremely important to the administration of the overall initiative process.
Additional questions from the bench? Thank you, counsel.
Thank you very much.
Attorney Woodcock, I believe you reserved some time for rebuttal.
I did. Thank you, Your Honor. First, I would like to make it clear, we did not suggest there was collusion between the plaintiffs in the We the People case and the Secretary. What we said was...
That it was non-adversarial.
Well, let me explain that. These provisions were in the proposal for a preliminary injunction as submitted by the plaintiffs. That's why they were in the initial motion, so they just never were contested. So we're not arguing collusion. We're arguing they were non-adversarial, as the Chief Justice has said. Second, with respect to the consent order, the consent order, given its nature, could have been intended to be very light on the out-of-state circulators, and it could have been structured so that when an occasion arose, if the Secretary needed an out-of-state circulator to respond, and at that point the out-of-state circulator did not respond, then there would be a potential violation outside of the injunction. There's nothing in that consent order, as Justice Douglas was pointing out, there's nothing in the consent order that has any timing element in it. There's no reason why the court couldn't have put a timing element in it. And in this case,
But is the fact that it doesn't specify the timing mean that the timing is necessarily irrelevant? I mean, you seem to be saying it doesn't matter.
I'm not saying it is irrelevant. I'm saying it is dependent upon when that circulator's cooperation is required. I didn't write this consent agreement. The secretary helped write this consent agreement.
But there's a clear statutory regulation, and indeed it's in the Constitution, about the circulator's oath. Why is that not an appropriate place to look for the
Well,
timing?
I find it remarkable that we're dealing here with a Constitution that simply excludes out-of-state circulators, and somehow the Constitution and now statutory law is the source of enabling them. The exclusion of out-of-state circulators is comprehensive. There's no limitation to it, and if it were to be adjusted, if the people of Maine wanted to adjust it, they should have that legislative opportunity of their own. There's a point at which I think the secretary said that the people would prefer or the framers would prefer a half a loaf rather than a whole loaf, but the oven belongs to the people of Maine under Article 10, Section 4 of the Maine Constitution. They get to make that decision. It can't come from any other source. I would note this case is not, by the way, Ayotte versus.
They still have that opportunity, do they not?
Of course they do. But they are essentially being co-opted by this consent order, particularly as very aggressively interpreted by the secretary to include all the
Co-opted or motivated.
Pardon?
Either co-opted or motivated.
Well,
And the people of the state of Maine could amend the Constitution to say there are no limitations on out-of-state circulators. In other words, the position you would be advocating for.
I would say as we stand here right now, listening to what the secretary is saying, the secretary has no incentive to seek that change. The secretary has all the power she would like. The federal court has given her that power and has now, and the secretary has infused into it all her statutory power. The people of Maine and their constitutional authority have been cut out of this process. So I do think it's important for this court to keep the secretary within her lane, in her constitutional lane, and not to appropriate statutory authority that comes solely from Article 4, Part 3, Section 22, and turn it into something that it is not.
Thank you, counsel.
Thank you.
Thank you, counsel, for the argument here this morning. As is our usual practice, we will issue a written decision. I won't say in due course because there is a statutory deadline rapidly approaching, and we obviously intend to meet that deadline. With that, the court will be in recess this morning.
All rise.